The National Labor Relations Act prohibits labor unions from inducing customers to boycott secondary retailers. In National Labor Relations Board versus Fruit and Vegetable Packers and Warehousemen, Local 760, the Supreme Court considered whether the act prohibits secondary boycotts if limited in scope. The Fruit and Vegetable Packers and Warehousemen, Local 760 Workers Union, called a strike against fruit packing companies that sold Washington state apples. As part of the strike, the union picketed at several Safeway retail stores that sold the apples but were not involved in the labor dispute. The picketers passed out flyers that urged customers not to buy the apples. Before picketing at each store, the union gave each store manager a letter that stated that the picketers weren't allowed to ask customers not to patronize the Safeway store. Aside from asking customers not to buy the apples, the picketers didn't disturb any of the store's operations. Nonetheless, the National Labor Relations Board determined that the picketing violated Section 8B.4 of the National Labor Relations Act. The United States Court of Appeals for the District of Columbia Circuit set aside the board's order, and the Supreme Court granted cert.